All right, welcome back. This is the capsule on the beginning of Chapter 5, which is our last one for this week. And you have issues there that we've discussed before to some extent, right? So we talked about discretion in the sense of a decision maker being subject to charter values. That's one of the contexts in which we explored it. And we said that sometimes the statute will be vague, which is what discretion is, right? So it will say, this person has the power is defined broadly. And it might even say, right, they can exercise a power however they see fit, right? These wouldn't be the exact words being used. It would be when it's in the interest of, right, the statutory scheme, in the interest of Canada, whatever it is. Usually it's phrased broadly because the government wants there to be wiggle room for the decision maker to consider various things that, frankly, first, usually aren't provided in the statute, and second, which might not have been foreseen by the government when the scheme was put in place. That's discretion. Of course, as we said, all the issues that we discussed earlier apply. So discretion has to be exercised first in a way that's compliant with the statute. That's jurisdiction. So if the statute says you have the power to do this and they do something more or something in part that exceeds that, then that decision is not valid in whole or in part because they exercise discretion, but it's not because the power is given to them to exercise discretion that they're allowed to exercise discretion that they don't have, right? They're still bound by the statutory scheme and therefore have to respect whatever is in there. Often the statute will also provide from some fettering of discretion, some guidance as to how the person's supposed to exercise their discretion. So, for example, it's going to say, in exercising their discretion, the minister shall have due regard to these four things. If that's the case, then it's an issue of, right, essentially jurisdiction. You look at whether or not the decision maker made the decision properly, right? If it's not jurisdiction, it's reasonableness of the substance of the decision. They have to consider whatever is in there. If it says they have to consider four things, they have to consider them, right? Again, that bounds their discretion. They can exercise their discretion, but only the one that they have in a way that's compliant with the statute. And we saw all these things with jurisdiction, right? The statute is going to limit the nature of the power of the decision maker some way, right? Whether that's by giving them certain power, by adding limits to that power, or by adding specifics as to what they're supposed to consider in exercising that power. So discretion implies, right, that they can make a bunch of decision or no decision. That's the definition of discretion, right? So if it says the minister can exercise their discretion, I think the example I gave you earlier is immigration. So immigration, you've got conditions. Some of the conditions are for sending someone back to some other country. And then there's conditions that say, right, we consider this, and then if it turns out that whatever's in there is met, we actually think the person's going to die if we send them back. We don't think that's good, so we won't send them back. Then you'll have another provision that'll say, the minister has the ability to waive the application of these conditions. Namely, the person doesn't meet them. Therefore, they're sent back to some other country. The minister has the ability to waive the application of the conditions, which would force a person to go back. They can say, I am granting an exception such that these conditions don't apply to you, and therefore I can make a decision, right, not to send you back to some other country, even though the statute would otherwise provide for that. Of course, the minister has to have that power in the first place. There has to be a provision that says the minister can waive the application. As you see there, it's general, right? It could be for any reason. Then you'd look at the statutory scheme, which bounds the power, of course. The minister has to exercise that power in a way that's consistent with the objectives of the statute, which would have something to do with immigration, right? Or the benefits of immigration to Canada. But beyond that, they can do whatever they want, right? They can decide when they feel that it's appropriate to do it, and when not. And not is not exercising their power, and that's discretion. There's always, as we said, right, some bounds to discretion, either in the statute or by virtue of the jurisdiction provided by statute. If not, the objective of the statute. You can always say that a decision, discretionary, is not reasonable because it's not consistent with the objectives of the statute. There's also certain issues that we talked about as to procedural fairness. The court always has the power to review discretion again, right? So if it's a discretionary decision, they have more wiggle room. The only thing that means is that the court is going to be more deferential. There's more than one possibility. The court will consider that. It's going to allow the discretionary power to be exercised whichever way, as long as it's within this range of outcome that defines discretion. The court then, right, doesn't really look at what it would have done or what it thinks the best decision would be, because by definition, discretion is not something that lends itself to a best decision. So the court exercises deference, right, therefore reasonableness review. It doesn't mean the court doesn't look at it. The court always has a right to look at it. We said that way too many times, right? The court always has a power to review. When it's a power that is where deference is owed, the court is going to exercise review deferentially. It's going to not intervene most of the time. But that never means, right, and actually never, the court does not have the power to look at it in the first place. In terms of remedies, if you have a discretionary power that is not exercised, it's something we'll talk about later on. It's one of the situations where the court will intervene. So you'll recall we said the court usually quashes a decision, right? Well, of course, if what you're saying is that the minister, so in my immigration example, didn't exercise their power, there's no decision to quash, right, namely cancel, because there's no decision. They just did not exercise their power. They denied your request. The court can quash that, send it back, and say, right, rethink your thing. If there's a systematic non-exercise of power, then the court can exercise what we call mandamus, which is to force the decision maker to make a decision. Not that important, but it's something we'll get back to. So the court always has jurisdiction to review a decision eventually, again, right, because that's what administrative law is. Government can put a lot of steps in your way before you get to the actual court, but at some point you have to get to the actual court because the Constitution says that. That means that you have all the obligations we saw, which apply by virtue of the Constitution, namely the Charter, right, can't make a discretionary decision in violation of your Charter rights, Charter values, which I won't get back into, but all that debate, right, doesn't apply as stringently, of course, because they're not rights, but still applies. And procedural fairness. They can't make a discretionary decision discriminatorily. They can't make a discretionary decision without hearing you. That's a denial of procedural fairness, and that is an inherent obligation by virtue of the Constitution, therefore always applies, even if the statute doesn't provide for it, right? Because it's the Constitution that provides for these procedural fairness obligations, which again vary in scope and stringency depending on the importance of the decision being made on the person's life. Again, right, we said that before, if they take away a lot of your rights or important ones, right, you'll have lots of procedural fairness. They'll really make sure that you had a chance to be heard and rebut that case. That also doesn't mean, right, that the substance of the decision cannot be reviewed, because it's still subject to reasonableness review. So of course, if they exercise a power they don't have, the decision maker, then it's a jurisdictional issue. Court can quash it. If they exercise that power in a way that's not consistent with the statute, the conditions they have to consider, same thing. But the decision itself, right, can also be unreasonable. It can be that even if you had a wide range of outcomes, the outcome that was picked was just not one of them. So sometimes, right, the minister is going to have to consider the facts, and the facts will just very clearly point to something else in the decision that was made. And so that's something the court can review, because again, everything's subject to review. So the court's going to show deference. It's going to allow for a range of outcomes, of potential outcomes, under reasonableness review. The decision can still be unreasonable. It can still be that it's just not one of the outcomes, right? It turns out that this case, right, speaks for itself when you look at the facts, and therefore it's simply not appropriate for the minister to say deny what they are being asked to give the person. So, for example, in my immigration example, you have a list, page 225, of the factors that historically were reasons for judicial review. That doesn't apply anymore, but it kind of does, right? First, bad faith. That's basically a denial of procedural fairness. The power is exercised unfairly, or is exercised, right, in a way that's completely unrelated to the scheme. So, for example, right, they deny you the discretion under the immigration statute because of, right, a factor that has nothing to do with the case, right? Might be discrimination, then it would fall under the charter. It can be something else, right? It can be some personal characteristic that doesn't count as discrimination. That's completely unrelated to the decision. Then, right, it's no longer called these things because they don't apply anymore, but it's essentially denial of procedural fairness. Consideration of an irrelevant ground or improper purpose, same thing, right? That's either not within the conditions of the statute, or it's a denial of procedural fairness because the decision is based on something that's not relevant. It's not, right, related to what they're supposed to consider. Failure to consider relevant ground, same thing. Patent unreasonableness, again, whenever you read that, you just forget about it because it no longer exists and it's extremely confusing. Fettering discretion, again, if the government, right, provides for limits, which are essentially less deference. The government's going to say, you have this broad power, but you have to consider this. Then the court, of course, is going to have due regard to that. It's not going to be more deferential than the government intended it to be. And discrimination, as we said, that was historically a reason why you could quash an administrative decision, including a discretionary one, essentially on procedural fairness. But now it's simpler because the charter applies, right? Charter provides for protection against discrimination. Most of the time, charter is going to apply directly to an administrative decision, including a discretionary one. Therefore, right, you don't have to do it indirectly by calling it something else because the charter now exists and applies. And that is essentially it for this week. I just want to emphasize one thing that we very, very briefly mentioned last week, which is an exception to the delegation principles. We said, right, delegation still applies. So if you have discretion of someone, they cannot subdelegate that power, and that includes a discretionary power, to some other entity. It just doesn't work that way. You can delegate it once, not twice, because it's not the intent of the legislator, and that is always the default rule. Unless, right, there's an exception. Generally, the legislator has suggested otherwise some way. You'll recall there's an exception, right, which is called Croton principle. Not important to remember it in detail, but essentially when it's the minister, it doesn't apply. And I explained that, I think, last week. I said, right, if it's the minister that has a power under a statute, they can delegate that power to some other senior official without having the right to do that. So the statute won't have to say the minister has the power to delegate, or the minister or a delegate of the minister. It can just say the minister, and by default, when it's the minister, they have the power to delegate it to some other senior official. And as I explained last week, the reason for that is essentially that statutes provides for powers that are exercised by the minister, generally discretionary powers, generally similar to what I said. So the power to waive the application of a standard, and therefore, right, for essentially humanitarian grounds, not send the person back to some other country. The statute will generally provide that is exercised by the minister, but with the assumption that there is no way the minister will do that themselves, right? Because there's no way the minister can consider all of the individual cases of people who are claiming that, right? The minister in the sense of the actual physical person who got elected gets a driven car, right? that physical person can't do it, and so it's just consistent with the nature of the statutory scheme that they can delegate it, because often that's implicitly, right, the expectation of the legislator. But again, it's not an exception because it's implicit. It's an exception because it's a separate category and it's the minister. And we'll stop there for this week.